Okay, I'm going to share my screen. So hopefully you're seeing our slideshow. Is that right? Great. Okay. So for those of you who haven't met me, my name is Reggie O'Rourke, and I serve as Associate Counsel of the program. And I work here in the state office with Matt and Liz and the other folks here in the state office. So I'm grateful to be here. And just like Matt said, we are really excited and passionate about this work. It's been really a labor of love for us, and we've spent a lot of time and effort and energy working together with each other, but also working with you on this training or on this material and on this training. So I'm going to talk. My section is divided into 4 parts, and we're going to talk about this, just how we got to where we are with our newest version of the templates. We'll talk about statutory changes, and most specifically, or the most significant statutory change is the 2 tracks to permanence. We'll talk about choosing a permanent plan. And in this section, I'll also talk about the youth transition to adulthood, or the youth transition to independence court report. So those middle 2 bullets, and actually I should say the 3rd bullet, the most questions we got were really about permanency planning, and then about the tribal, cultural, religious, and other diversity needs and considerations section. Those are the 2 sections that we got the most questions about. It seems like the most interest about, and so we will address the first part of that, the permanency planning part, in this section, and then Liz later on will address the tribal, cultural, religious, and other diversity needs or considerations section later on. So we received a lot of feedback from you and from GL staff, GL attorney advocates. Every part of our program we received feedback from, and we are grateful for it. And if you have additional feedback, we will. I've seen some things in the chat, some questions in the chat that I've responded to, and that we will continue to receive that feedback. So thank you very much, because that's what helps to make these so effective, makes the court reports and templates so effective. And so we carefully reviewed all that feedback. We took days, if not weeks, to review the feedback, or maybe even months to review all the feedback. And we discussed every bit of it, and we made changes accordingly. We didn't make every change that was requested, but we made most of them, if not probably most of them. And there was some duplication in some of the feedback. So when there was duplication, that also helped us to see that this is a really important issue, and it helped us to really hone in on what we needed to change and how we needed to improve the templates and the instructions. So I'll just give you an example. We won't go through all of the changes that we made. Liz created a 4-page document of the changes that were made, and you will get that. We suggest that you not give that to your volunteers, since we just want the volunteers to be using the new materials. But for you as a staff, or you as attorney advocates, you may want to look at that just to know what changed. As I said, it is 4 pages, so there were a lot of changes that were made. Some of them were substantive, some of them were in the instructions only, some of them were to the actual templates themselves, and some things were typographical or clerical, just typographical errors that were made. But there were a lot of changes that were made. So one example of a change is this first one here, where in the parents, in the dispositional template, there was not a parent's current information section. And so there was a lot of feedback about asking for that section to be added. So we did add that section. And then along with that, we added a section for the guardians, custodians, or caretakers also, so that you can, at that dispositional hearing, you can provide current information. So there may be some things that have changed since the time the petition was filed, or maybe you had a dispositional hearing that was 30 days after, or within 30 days, but not immediately after the adjudication hearing. So we added this so you can keep the court up to date with the current information about that family and about those parents. So we also updated the permanency planning instructions. You guys wanted some help with that, so we added a number of different things to the permanency planning instructions. And of course, the statute changed significantly with respect to permanency planning, and so we made changes in line with those changes. We changed the title of the tribal, cultural, religious, and other diversity needs or considerations section. That what you see there is our current title. We changed it to be more positive. We changed it to really be more inclusive, and with the understanding also, and we've always had this understanding and this recognition that every family has cultural one, and we're going to talk about that. We want to preserve and safeguard the culture of all of our families for our child clients. And we listened to you. One of the major pieces of feedback that we got was wanting specific training on that section, and so I'm really excited that Liz is going to lead us in that later on today. So Matt is really into music, as is Liz, and many of you are. And so this is a reference from Spinal Tap. I feel like Matt created these slides, and I'm having to figure out, like, what was this reference about? And so this, I do know this one. This was from Spinal Tap. So anyway, I got it right. Thank you. Thanks, Matt. Okay, so we're going to move to the major statutory changes, and there were a lot of statutory changes, but we're going to move to the ones that really impacted the templates. And that's really that there are now, as you know, 2 tracks for cases. Our cases are going to proceed on 2 tracks. There's going to be a review track and a permanency planning track. And so I quoted the statute here. The statute rather is quoted here that the difference is going to be at that 90-day hearing. So we used to call it a 90-day review hearing. Now we're just calling it a 90-day hearing. So if custody was removed and remained removed prior to that, or prior to the initial disposition hearing, then you're going to be on that permanency planning track. If custody was not removed at that initial disposition hearing, then you're going to be on that review track. So say, for example, the child was initially placed in non-severe custody, but then non-severe custody was returned to the parents, or the parents, or rather the non-severe custody was dissolved. And then you get to that disposition hearing and custody remains with the parents. Well, you're going to be on that review track. So even though custody was removed at the time of that initial disposition hearing, custody remained with the parents. So that's going to put you on the review track. If custody was removed at that initial disposition hearing, or was continued to be removed at that initial disposition hearing, you're going to be on the permanency planning track. So those are our 2 tracks now. And so, and I will say that parent attorneys were excited about that change, and we can embrace that change, because we want to just acknowledge and remember that when custody is removed, that is a traumatic event for the child, even if it needs to happen for that child. And so that's just kind of a reminder of that. So looking at permanency planning hearings in that second bullet, just some of the differences about our templates, and also really about the findings of fact that are required at a permanency planning hearing is you got to have 15 days notice to have that permanency planning hearing. That's by statute. Those permanency planning hearings, we do need to have permanency planning recommendations in our report, because at that permanency planning hearing, the court is required to make findings about the primary and secondary permanent plans and why those are appropriate. And there may need to be findings if reunification efforts are eliminated. There's going to be additional findings that are going to be required at those permanency planning hearings. And so our reports will help courts to be able to make those findings, but provided that we're using the appropriate report. So that will help the court to make those findings. So a lot of what the issues are going to be for you is how to change tracks and why changing tracks. So change tracks if there are safety concerns. You know, if the child is, if there's safety concerns with the child remaining in that home, we need to clearly articulate what those safety concerns are. And then we can kind of consider asking the court to change tracks. And our court reports are a great way to do that. This next bullet and the sub bullet is really just an acknowledgement that we do not have to view things like DHHS or DSS does, but it's important to understand how they view safety and risk, and how they may view changing tracks. So we have a link here in this, on this template or in this slide, for you to look at the DSS manual to get an understanding about how DSS views safety and risk, and how they view the child's remaining in the home. So I will read this passage from the manual. It says, the removal of a child from their home should occur only when the risk of harm to the child is so great that safety cannot be assured in the home. The decision to remove a child should be based on an analysis of the risk of harm balanced with implementing reasonable efforts to ensure safety within the family. So that really will let you hone in on how DSS views this, and maybe perhaps how your court views this. We're not limited to that, but it is important to consider that when considering how we're going to move tracks, or move from the review track to the permanency planning track. And so really another way of looking at this and focusing is, what's the safety risk right now for this child being in this home? What's the risk of harm for this child remaining in the home right now? And another part of that is, are there any safety measures that can be provided in the home to maintain the safety of that placement, the security of that placement? Okay. So now we're going to move to a series of scenarios, and we're going to use our poll to do this. And so we're going to ask you to make the call. And this is I will let you know that we haven't designated a right answer for this. I think it's most important that just you can support your answer, and there may be better answers, but we're asking you to kind of use your best judgment based on what you see here, and then make the best call that you can. And when you're working with your volunteers on this, if you actually use this section as it is with the volunteers, this is a great opportunity for you to talk with the volunteers about safety and risk, and helping the volunteer to have some criteria to make that decision about whether custody should be removed, or whether you would recommend that custody remain with the parents. It's okay, you make the call. So here's our scenario. I'll read the scenario for you, and you can read it to yourself. The petition was filed 3 months ago, alleging neglect based on poor hygiene. There are 3 cases of head lice, inappropriately sized clothing, and deplorable home conditions. The family has also been uncooperative in the past about providing the children's vaccination records to their school. The children were permitted to stay in the parents' home because CPS determined that the conditions were not dangerous. The family has a prior history with CPS in another state, where the parents' rights were involuntarily terminated to another child based on similar neglect. The family has engaged in intensive in-home family services, including therapy to address anger management and improper discipline issues. And the children have also been connected with mentors. So that's our scenario. Here's our question. We're essentially asking you, what track should you be on? Should you be on that review track? Should we be on the permanency planning hearing track? So what track should we be on? What do we want? What should follow? A review hearing or a permanency planning hearing?
So Reggie, our poll is not opening up. So we're going to ask everybody to just pick A or B and put it in their chat. And they're quickly doing that. So.
Okay. So Liz, I don't know that I can't see let's see if I can see Yeah, I'm not able to see the.
Okay, I can give you the feedback here. We got a
Okay.
lot of A.
A lot of A. Okay.
Yes, a very lot of number of letter A. Yep,
Okay.
almost everyone.
So we'll ask for a volunteer, someone who chose A, if you would explain just why you chose A. Can you pick someone, Liz, if you see someone or someone volunteering, someone raising their hand maybe?
I'm looking. Let's see
Okay.
quickly. I don't see anybody raising their hand.
Oh, Sebastian has a raised hand. I see.
Awesome. Thank you. I didn't get to. Thank you, Sebastian.
Just reading this scenario, it sounds like I chose A because while there are issues in the home, the children were permitted to stay in the home, and it looks like they are cooperating to some extent. They are working the plan and making slow progress. So as long as they're making some progress, hopefully you can keep working with them and get them to where you would want them to be.
Thanks so much for being brave, Sebastian. We really appreciate it, and thanks for that feedback. So is there someone who chose B who would be willing to volunteer? Or did anyone choose B?
I didn't see a single B.
There was not a single B. Okay. All right. So I highlighted some of the key facts. Maybe someone could have. Sorry, go ahead, Liz.
I said there's a couple,
Okay.
but no, go ahead.
Okay.
Reggie.
So someone might have chosen B if deplorable home conditions meant to them that there was a safety concern in the home, that maybe there was something physically wrong with the home, like floorboards falling in or something of that nature. So maybe that was viewed in that regard. To the point to what Sebastian said, there are one of the things that maybe would support the children remaining in the home is it seems like there are a lot of people going into the home, meaning you got the intensive in-home people going into the home. Mentors are seeing the kids, maybe the schools are seeing the kids also. So maybe there's a lot of people that are laying eyes on these kids to make sure that there's safety, that they're safe. I will say that these scenarios are very limited, and you all, the petitions hopefully are more than this, but sometimes this might be all that you have in a petition. But with our independent investigation, you're going to have more facts. So we understand that this is very limited. So thanks to everybody for participating. So we're going to move on. We're going to move on to our next scenario. So the facts are going to continue to evolve. So just keep that in mind. So since the first review hearing, the guardian ad litem has continued to contact the children and family, as well as collateral sources of information. Conditions in the home have improved, but the GAL has observed roaches and an odor of urine near the bathroom. Otherwise, the home appears well kept. The family's therapist reports that the mother has little impulse control and reacts with anger when she feels threatened. The GAL also has seen the mother kick the family dog when it barks. The family therapist is working with the mother on impulse control and appropriate discipline. And the parents and the children share a strong bond. And based on the GAL's observations of their physical affection toward each other and their positive statements, the GAL has observed. The GAL based on GAL's observations of their physical affection toward each other and their positive statements about each other. So that's how they came to that conclusion about the strong bonds. So we're going to move to our poll. Should we continue to recommend rather that the children remain in the home, or should we recommend that the children be removed from their home and have a permanency planning hearing? What do you think? I'm seeing a lot of A's. I haven't seen a B yet. Still seeing a lot of A's. I've not seen a B. Remain A. Okay. All right. Well, it seems like there's unanimity that everyone's recommending that the children remain in the home. And so I just highlighted some of the facts, some of the key facts. All right, so does anyone actually, you know what, I'm going to move on past this one. I won't debrief on this one since there's unanimity and since they're similar to the first scenario. We'll move to our third scenario. Oh, I'm sorry, we'll move to how to change tracks. So changing tracks. One way of changing tracks is to ask our attorney advocate to file a motion to request a permanency planning hearing. And there needs to be at least 15 days notice of that. And then in that court report, we would need to document what those safety issues are, what the reason for wanting to change tracks is. And we would likely, in our recommendation section, ask, in recommendation number 1, we're recommending that custody be placed with DSS or someone other than the parents. And we may be asking and recommending that the child or children be removed from whatever placement they're in and moved to another placement. So our court report needs to kind of have all that. And then some of the kind of the statutory basis, if you will, for asking for a change is you can look at the dispositional alternatives in 7B903. You can look at the criteria for non-secure custody. That's in 7B503. I'm recommending this more for our attorney advocates, but also you can look there too and look at those criteria. So the criteria, for example, in 503 are the child's been abandoned, the child has suffered physical, sexual, or serious emotional abuse. The child is in need of medical care to prevent death, disfigurement, or substantial impairment. The child is a runaway and consents to non-secure custody, or the parents consent to non-secure custody. Those are the criteria in 503. The dispositional alternatives, one of the dispositional alternatives is just that the child or children be placed in the custody of the county. And in all candor, there's not, I didn't see any cases on those dispositional alternatives. So we're really going to be forging new appellate ground with this. So we may be asking for custody to be removed based on a dispositional alternative, and we may get an appeal on that, because we know that anytime custody changes at a hearing that's not a non-secure custody hearing, that makes that order appealable. And so we may be creating we may be creating new case law, but we recognize you need to do what you recommend is in the best interest for that child. So you don't need to be afraid to ask for the custody to be removed. Just letting you know that there's not a whole lot there that we have to judge how the court's going to view that, or how the appellate court's going to view that. And we also, of course, always want to look at what supports that recommendation and what are the safety concerns that are going on. So that's how we change tracks. That's one way we change tracks. Now we're going to move to kind of another way to change tracks. So you could also change tracks by, at the review hearing, just merely making a recommendation in your review template, using your review template for that review hearing, asking that custody be removed. And that, by doing that changes tracks. If the court does indeed change custody, then that does change tracks. And then the court is going to have to schedule a permanency planning hearing after that. And so that's what the first 2 bullets are about. And then that last third bullet with the sub bullets is what you saw that on the previous slide. Just to look at the dispositional alternatives, look at the criteria for non-secure custody, and consider safety. Okay. Were there any questions about that before we move on?
Reggie, there are a few questions in the chat looking for a little bit of clarification. So I'll just kind of summarize that. Can we recommend that DSS be awarded custody at a review hearing? If we want DSS to take custody, do we give notice that we want a permanency planning hearing and then use that template? And then another was kind of, I think up towards the beginning, which I think you've addressed now, which is if the department didn't take non-secure, then their only option really is a review hearing.
Yeah, so I'll answer that last question first. So if the department was not given or was not given by the court custody at the initial disposition hearing, the 90-day hearing is going to be a review hearing, and you're going to use your review template until something changes. So in answer to the first question that you asked, which was, I think it was something about like, can you ask for custody to be removed at a review hearing? Yes, you may. And you may use your review hearing template. You should use the review hearing template unless it's been noticed as a permanency planning hearing. Use your review hearing template, and then you're going to ask for custody to be removed. So that maybe like for your first recommendation, when we have the first recommendation is always about the custody of the child. That first recommendation would be that custody be given to DSS, or that custody be given to grandma, whoever you want custody to have, whoever to have custody, you put that in that first recommendation. But yes, you may use your review hearing template to ask for a change in custody. If we do that, then the court needs to schedule, and then the court does indeed remove custody at that hearing, they're going to have to immediately schedule a permanency planning hearing. And that's fine and appropriate. The statute says that. And so I believe this will also answer the second question that you asked, but I'll give a little bit more background. So if we change tracks in the manner that I just mentioned to you, if we change tracks by at a review hearing, custody is removed, then we've got to have that permanency planning hearing within 30 days. If we change tracks that way, we're having to have 2 hearings to change tracks. So court time is limited everywhere. We have high continuance rates at various places for various reasons. So you may not have time. In all candor, something may have come up within 15 days of that review hearing, and the best you can do is to put in your court report to asking the court to take custody. That may be the best that you can do, as far as you may not be able to eliminate the need for another hearing. If you have time, you can do what I mentioned first, which is ask your attorney advocate to notice that review hearing as a permanency planning hearing. And then you'd use your permanency planning court report template. And you use that template, and you're going to ask that custody be removed. And then you're going to recommend a primary and secondary permanent plan. So I hope that answers those questions. So I'm kind of envisioning 2 different basic ways of changing tracks. One is you ask at the review hearing for custody removed, and then you're going to have that permanency planning hearing. The other way is noticing that review hearing as a permanency planning hearing, and you use your permanency planning or court report template. And so those are the 2 basic ways of changing tracks. Now, the court on its own could change custody, and then you're going to, but maybe I shouldn't have gone into that, but the court on its own could remove custody at a review hearing, and then that's going to change tracks. Okay, so I hope that answered the question. Was that all the questions, Liz?
There are a few more, and I don't know if you want to wait until you get through your permanency decisions, and I can put them out there then to see if they.
Okay, let's do that.
Okay.
Thanks. Okay. So we all know the basic permanency, the essential permanent plans. So there's reunification, guardianship, custody, adoption, APLA, and then reinstatement of parental rights is your 6th permanent plan. So the next series of slides is just to provide a baseline about that. I know most of us here have been doing this work for a while, and so we should have this kind of rooted in our understanding. But reunification is defined in the statute, and here's the statutory definition. It's the placement of the juvenile in the home of either parent, or the placement of the juvenile in the home of the guardian or custodian from whose home the child was removed by court order. So that's our definite. We have a statutory definition of reunification. And sometimes people might forget that it does include return to the guardian or custodian. So adoption, not expressly defined in the juvenile code, but we know that that means the complete substitution of parental rights, either through a relinquishment, starting through the relinquishment or surrender, and then by the adoption of that child by the new parent. So that's adoption. And those are kind of, adoption and reunification are what we would refer to as the most permanent. And we refer to them as being the most permanent because of the difficulty there is in dissolving or disrupting that permanency. So obviously with a parent, the parent has intact parental rights, and with adoption, that a new adoptive parent has fully intact parental rights. So guardianship, we'll move to guardianship. With guardianship, the parent we still need to address visitation. So there are visitation issues that need to be addressed in guardianship and custody. And guardianship, we typically refer to that as maybe our second highest level of permanence because of the difficulty that there is in dissolving the guardianship. And so that last bullet has those 4 criteria that are in the juvenile code for removing that guardian. If the guardian's unfit, the guardian neglected their duties, the guardian's unwilling to continue as a guardian, so that guardian can say, hey, I'm no longer willing, and a lot of times we see guardians saying, I'm no longer willing and I want mom to get custody. Well, 2-part analysis. That first part is, yeah, okay, you don't want to be the guardian, so we can dissolve guardianship if that's what we have to do. But that doesn't mean that mom automatically regains custody just because the guardian dissolves. Guardian doesn't want to maintain the guardianship. And then the last one is the guardianship is no longer in the child's best interest, and that's a little bit vague. There's a lot of things that would factor in that. So guardianship defined by statute 7B-600. Another nuance is their guardianship can be awarded at any time as a dispositional alternative. When it's awarded as a dispositional alternative under 7B-600, I believe it's A, that's not doing it as a permanent plan. So just because guardianship's given doesn't mean it's done as a permanent plan. So when it's done under 7B-600B, that's doing it as a permanent plan. Okay. So custody is, our third permanency option. And it's very similar to guardianship. In both a guardianship order and a custody order, both of them must address visitation. Doesn't mean that there has to be visitation, but the court must address if there's no visitation, why there's no visitation, and what the parents need to do to regain visitation. So very similar to guardianship. Guardianship is unique in that only a guardian, for example, can consent to a minor joining the military, not a custodian. Of course, parents can do that, but between a guardianship and custody, custodian can't do that. Custodian also couldn't consent to a minor marrying. That's another difference between guardianship and custody. In talking with Matt about guardianship and custody, there's a lot of case law about guardianship, not a lot of case law about custody. And probably because, we all know that when parents aren't able to reunify, they tend to prefer custody. And because there's the perception that it's easier to dissolve that custodial relationship than in guardianship. And of course, when custody is given, custody can, that court order can remain in the 7B in the juvenile court, or it can be transferred to Chapter 50. As you hopefully remember, guardianship always remains in our 7B courtroom, in the juvenile A&D courtroom. Okay, we're not going to talk about APLA and reinstatement of parental rights. We're just going to focus on the first 3 that we mentioned. But it is important to know that these are first 4 that I mentioned. So it is important to know that APLA and reinstatement are permanent plans. They have separate and specific statutory considerations. So just know that. Okay, Liz, should we move to our question, or you want me to continue to go on? We're going to talk a little bit about the templates and the instructions.
So I sent them directly to you in your inbox, but I'll summarize there quickly so that you can kind of hear them as well, which is, if custody is granted temporarily to a kinship provider, does that mean we are on a permanency planning track? That's one question. Does the clerk's notice impact which report we prepare?
What was that one? Can you say that again?
Does the clerk's notice impact which report we prepare?
Does the clerk note
the clerk's notice?
Oh, should the clerk automatically notice it? You know, we need to make sure that they do, but I think also we can provide that notice by filing it and serving the parties. Sorry, go ahead.
No worries. The new change stating the child was, quote, removed from the parent custodian. This is specific that a local DSS attorney in court is viewing that as physically removed, not necessarily in DSS custody. They feel the new statute is vague when it comes to legal and physical custody. So that was a statement and then it's saying our DSS is asking the next hearing to be permanency planning if the child is placed in another home other than the parents, since the child is not in the physical custody of the parents. So that was kind of I think maybe looking for clarification or your thoughts. And then what about when DSS is asking to grant permanence at disposition prior to a plan being set? Do we also do that if we agree or not, because it isn't a permanency planning hearing?
So Liz, I'll talk really quickly about the first questions. I won't talk about the last one because my mind stopped because there were so many questions. So yeah. I'll just quickly address the first. There's really no case law on this. So yes, people are right to have questions because we don't. This is all new. We don't have appellate courts telling us how to interpret the statute in this way. I think I believe the intent was to focus on legal custody and not placement. But I can envision a parent filing a motion or trying to file an appeal saying that a change in placement was tantamount to a change in custody. But I believe the statute's talking about changes in custody, changes like when legal custody changes. So that's my perception of that. But as I said, case law hasn't really there's been no adjudication of these issues because we haven't had enough time because this just went into effect October 1st. Liz, I don't know if you want to say that last question again, and I can try to answer it quickly.
And Reggie, we can also try to send, I know who they're from, so we can also send email replies and put together a list of questions to send out to everybody as well. So the last one was, what about instances where DSS is asking to grant permanence at disposition to a plan being set, prior to a plan being set? Okay. Do we also do that if we agree, or don't we, because it isn't a permanency planning hearing?
So great question. So first there has to be a legal ability to do that. So granting guardianship and waiving reviews at the disposition hearing probably can't happen because of the amount of time that the child needs to have been in that placement. So I don't see that, or guardianship or custody, I don't see that could really happen. I mean, if custody is given to a parent, then there's statutory support for being able to waive reviews then. So I may need to, that's a nuanced question. I probably need to get more to consider that more. But that's a great question. So keep asking the questions. I'm a little bit behind on time, so I might not be able to answer all of them right now, or maybe a whole lot more of them, but we will record them and get the answers to you. So I just wanted to highlight on this slide that there is a statutory preference for reunification, and there was one before the recent statutory changes, and really the new statutory changes really highlight the importance or highlight the preference for keeping kids in their home. So, and just knowing that when the kind of the standard at your disposition here, at your permanency planning hearing, the standard for ceasing reunification efforts is really, would reunification efforts be unsuccessful or inconsistent with the child's health or safety? Okay. These are examples for rationales for your primary and secondary permanent plans, and they're in the template guide that we gave you. And so you can, hopefully they will be instructive and useful for volunteers. We're going to move to another scenario. So get ready to, to respond in our chat. So since the first review hearing, the guardian ad litem has continued to contact the children and family, as well as collateral sources of information. Conditions in the home have improved, but the GAL observed roaches and the odor of urine near the bathroom. Otherwise, the home appears well kept. The family's therapist reports that the mother has little impulse control and reacts with anger when she feels threatened. The guardian ad litem has also frequently seen the mother kick the family dog when it barks. The family therapist is working with the mother on impulse control and appropriate discipline. The parents and the children share a strong bond based on the GL's observations of their physical affection toward each other and their positive statements about each other. So the identified relatives seem appropriate, but they live out of state. So what should you recommend as your primary permanent plan? And we'll start with it. We're going to do the secondary also. We'll start with the primary. What do you recommend as your primary permanent plan? I'll give you about 30 seconds to put that in. This is for the primary permanent plan. What should the primary permanent plan be? See a bunch of A's. Only A's. Okay. All right. So I'm going to ask you to stop entering on that. And then we're going to move to secondary permanent plan. What should the secondary permanent plan be? Guardianship. CD. Okay. So since there was unanimity on the primary permanent plan, and we're a little bit behind on time, I'm just going to ask someone if they would give feedback as to why they chose C or D. There was one A for the prime. Okay, so I saw one A for the secondary permanent plan. So if someone said A for the secondary permanent plan of reunification, okay, they changed it. I guess maybe that person changed their vote. So someone speak about their recommendation for the secondary permanent plan. So just someone raise their hand, whatever they recommended, just so we can talk about that.
This is Melanie. I raised my hand. I picked guardianship because I feel like the custody is one of the least permanent plans for permanency for children, and guardianship would be the second best. And because the family has shown some evidence of trying to work on their plan, that at least guardianship, if we can't reunify the family, then guardianship is still a permanency that allow the parents to still work on some things, that if they see that the courts that they have done well, that those kids can be returned. If they cannot, at least they have some type of permanency plan in place for the children's well-being.
Melanie, thank you so much. Melanie, may I ask you one question? I'm sorry. What sure. Did you also recommend A? I'm assuming you recommended A for the primary.
A for the primary. Yes, I did.
Awesome. Thank you so much, Melanie, for that thoughtful explanation in very short period of time. you really had so many excellent points about allowing the family to be able to continue to work if that plan had to be implemented, and really thoughtful. So thank you so much for that thoughtful explanation. Rationale for your secondary permanent plan. That was really helpful and really good to hear. Okay, so let's move. Was there a question, Liz? No. Okay, let's move to our. The scenario has evolved. Okay, We're just saying for the sake that we got on the permanency planning track. We're not saying that that was right. We're just saying that that's what happened. So you're on the, since the first permanency planning hearing, the GAL has continued to contact the child and the family, as well as collateral sources of information. After the first permanency planning hearing, the children were placed in a foster home. Conditions in the home have improved and it appears well kept. The family's therapist reports that the children have, the mother has little impulse control and reacts with anger when she feels threatened. The guardian ad litem has also frequently seen the mother kick the dog when it barks. The family therapist is working with the mother on impulse control and appropriate discipline techniques, but her progress is very limited. The mother reports that the therapist doesn't understand her or her children. The parents and the children share a bond, but it is weakened now that the children have been removed from the home. The paternal grandfather, who has served as a visiting resource, is bonded with the children. If the parents cannot reunify, he wants the kids to stay with family. Okay, so there's our scenario. What's your recommendation for the primary permanent plan? Give you about 30 seconds. Okay. All A's, all right. What's your recommendation for the secondary permanent plan? Okay, great. So would someone just speak to why they recommended the primary and secondary permanent plans? Just talk to both. And is anyone raising their hand? Or will anyone volunteer?
Reggie, I see Rhonda put part of her explanation in there, so maybe she'd like to speak to that.
And I saw Mary Jo raised her hand. So, thanks, Mary Jo. Will you unmute yourself and tell us why you chose the plans that you did?
I went with majority of cases. I agree we need to consider the age. That might make a difference on it, but overall, our cases, I see custody as a good option for our children, and in that scenario, particularly since we don't know the ages of the children.
Okay, thank you. So we consider the age of the children. So the age of the children may have changed what permanency option you chose. Is that what you're saying? Okay, and you chose, I'm assuming you chose primary as reunification and secondary. What was your secondary permanent plan?
Primary was reunification. Secondary most of the time is custody.
Custody. Okay. Thank you so much, Mary Jo. I really appreciate you speaking up. Okay. So we had a third scenario, but based on our time, I'm gonna skip it. And of course, you know, we would want to know more information from that from the relative about what permanency option they preferred, and you know what they could afford and all the things of that nature. But we understand these facts are pretty limited, so we're going to skip this third scenario. But you will have it in the slides, and you can discuss it with volunteers, and we're going to move on. So there's an addition to 7903, and it really takes the language that was in our non-secure statute in Article 5 about the ability to, the court's ability to identify relatives and others with legal custody of a sibling. And also it's important to notify the child's state recognized tribe if they're a member of the state recognized tribe. So that language, it was kind of imported from Article 5 and brought into our dispositional statute. So now we can make those considerations and recommendations with some legal footing when we're in our dispositional hearings or in either the initial disposition hearing or in your review or permanency planning hearings. Okay, let's move to the youth transition to adulthood, youth transition to independence report. So we envision this report as helping to ensure that that 18-year-old has a smooth transition to adulthood. And this report and the changes in the statute are about the court's role in helping to make sure that that transition is a smooth one. And so this court report can be used at any time, but there must be a permanency planning, or immediately following the child's 17th birthday, there must be a hearing to address these issues. Must be a permanency planning hearing to address these issues for the 17-year-olds above. So we can use this before the child turns 17. I know some of you had comments and questions and thoughts about that. And yes, good idea to if you're able to use this report earlier, go ahead and use it. But we must have a hearing immediately following the child's 17th birthday on these issues. So how do you use it? Well, we envision you preparing it to make sure that child transitions out, that young adult transitions out of the child welfare system with all of the resources that they need. We envision you working on the report with that youth and giving that young person the opportunity to review the report, if that's appropriate. And then we want to encourage court attendance. You know, I understand that jurisdictions differ across the state about how welcome or unwelcome young people are in the courtroom. But you know, to the extent that we can, we want to encourage court to be a place that's trauma informed and conducive for young people to attend, and certainly young people who are aging out. We want to give them a voice and let their voice be heard by the court. And I think that has a really positive impact on the courts. Okay, so here are the statutory changes. I won't go through them all on this slide, but just know that our court report template, we've now updated section F, where it has prompts for the volunteer to investigate and put in information about each one of those statutory changes. So what's the housing plan for that young person? Are there identified adult supports? Are there, what's going to be sibling contact when that young person ages out? What job skills is that young person being provided with? What's the educational plan? What's the employment and income plan for that child? Health insurance. Okay, so we're at the end of this section. We're 6 minutes early. If there are any questions, we'll do that. And if not, then we'll break, and we'll have until we'll return at 10:40. So seeing no questions, let's just break. And make sure that we are adhering to what we advise that we give you, the breaks that you need. And so we'll come back at 10:40, and we're going to resume with Matt talking about court report writing. And thank all of you. I thank all of you for letting me talk with you.